Hello, and welcome to today's meeting. As part of the executive leadership team here at the USAFD, I wanted to take this opportunity to address all of you regarding some new policies that we've currently created. These policies have been created to protect each individual in our organization as well as the organization itself. The first policy that I want to discuss is our new social media policy. I'm sure that you're all very aware of the numerous cases that have made national news over the last few years regarding members of the first responder community, either losing their jobs or being sued for images or content that they've posted online. This policy was designed to help more clarify and define what is considered prohibited behavior regarding social media so that you may be made aware and refrain from bringing harm to yourself or the organization. Images that could breach patient confidentiality or even be illegally obtained, images related to legal proceedings such as evidence, and images of an embarrassing nature or images that are public record, even when on personal devices or that are on your personal devices, are strictly prohibited from being posted and shared from any member of the fire department, whether you are on or off duty. Because you're a member of the USAFD, you represent our organization even when you're away from work and posting messages as a private citizen. Therefore, I want each of you to think hard about what you decide to post on social media accounts. Images depicting you in embarrassing or unethical situations such as in various stages of undress, using or consuming drugs or alcohol, or sharing or posting divisive and or insensitive material will now result in formal discipline up to and including termination. Again, I really want to enforce that this policy has been created not to punish members for using social media, but rather to protect you from the very serious implications that can result from a momentary lapse of judgment. Many of you may say that it's your right as a private citizen to post and share anything that you wish on social media under the Constitution. You're correct. As a private citizen, you have the right to free speech under the First Amendment to the Constitution. However, as your employer, we also have the right to terminate your employment if your speech were to cast our organization in a disparaging light or breach laws surrounding evidence collection and a person's right to privacy. Some of you may argue that anything you post could result in discipline because the interpretation of what is not offensive or what is offensive is very subjective based on the individual's interpretation on the post. My suggestion is that you follow this advice and this logic to filter what you post and share on social media. Always ask yourself before you post a message, picture, or video of the post, would this embarrass me? Would this hurt someone that I know or love or members of the community or my coworkers? Think about the different backgrounds, races, genders, ethnicity, or political beliefs. These are the people that are going to be reading your posts. Everything you post stays on the internet forever and cannot be shared with select individuals. It's actually shared potentially with the entire world. So when you post, do so at your own peril. A good rule of thumb is that if you have to stop and think to yourself, is this post something that I could get in trouble for? Don't post it. The next policy that I want to discuss today is the FLMA leave use policy. Again, this policy was created to protect you as an employee. The Family and Medical Leave Act, also known as FMLA, entitles eligible employees of covered employers such as us, the USAFD, to take unpaid job-protected leave for specified family and medical reasons, with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken the leave. So again, you can be out on leave and your job will remain intact as long as you follow the guidelines that I'm about to share with you. In the event of childbirth, adoption, or serious health conditions involving the employee or their immediate family, the employee may take leave. With the completed Job Protection Act, you can take up to 12 weeks of leave in a 12-month rolling period. In order to properly follow the law, we need each employee to immediately notify the Human Resources Department when you are made aware of an impending situation that will require you to take leave in excess of 72 hours. Preferably, under the law, notification should be made to the HR department 30 days prior to taking the leave. You have all had the chance to review the policy prior to today's meeting, but I wanted to talk to you about some concerns that I felt that you may have. For those of you that are fairly new, you may have only acquired a small amount of paid leave compared to other employees that are more senior in the department. And you may worry that even if the FMLA applies to you, you don't have enough vacation that will cover you in the event that you're out for an extended absence. Fortunately, we have created a sick leave donation pool for such situations. Any member that is taking FMLA leave may apply to receive donated paid leave hours as long as you agree to donate your accrued hours back to the pool once you've returned to work. This is not a legal obligation of the department, but rather a way to assist employees that are dealing with a hardship. The idea behind FMLA in conjunction with the department's sick leave pool is to help prevent challenges that come from a serious medical leave or disease or injury to you or an immediate family member from being compounded by the loss of your employment. Several of you may have foster or adoptive children living with you, or you may be an adoptive child yourself and don't have a blood-related family member that you have to take care of. You do not have to be related by blood to qualify for leave under the FMLA Act. However, non-immediate family does not qualify. Additionally, if you serve in the military or have a spouse that serves and would be faced with child care issues during the active duty of deployment, you also qualify under FMLA. Childbirth and adoption are also covered in FMLA for both the mother and the father to maximize to a maximum of 12 weeks, again, in a rolling 12-month period. Failure to notify HR of an impending leave will not result in discipline. Rather, it just may limit your ability to effectively use the leave under the FMLA Act. If you have any questions about the policies that I've covered today, please feel free to contact me or anyone in the Human Resources Department. Again, I wanted to make sure that everybody understands these policies that we're rolling out are there to protect you as an employee and as a member of our department. So I appreciate you for taking the time to watch this video today, and please review and follow all of the guidelines that are set forth in the policy. Thank you.